marijuana, crack cocaine. Those were the two predominant drugs that were being sold at that location.
Were you ever in a position to determine who or what was allowed to conduct that type of activity at a green store?
If you weren't from, it was our understanding and our knowledge that from just talking to people in the street, and obviously, you know, in that arena, we always had
basis.
You're saying competition.
I'm going to overrule your objection, sir. Okay.
So we make a point to try to interact with people within the community, people that maybe we've arrested before and would like to give us information. The word that we had gotten and what we could see was that if you were operating any kind of illegal activity at that location, you had permission to do so, or you were involved with the group that kind of had authority there, for lack of a better word.
Were you in a position to know which group kind of had authority there?
In that area at the time was primarily 30 deep, and then there was some talks of.
Objection, Your Honor. You're saying.
I sustain your objection.
Without getting into talks of, did you observe any other groups who appeared to have authority there?
30 deep was the primary for us.
So on this particular day, is it that you set out and actually went to the green store or 322 Glen in order to find Mr. Stillwell?
Yes.
All right. Who all went with you?
It was myself, Viverito, and Officer Flewellen. We're in an undercover vehicle trying to locate. And then the tactical units, the marked units were Officer Weber, at the time Sergeant Jimenez, and Sergeant Heckenkamp, who were close in the area as well.
Okay. Were you all able to locate Shannon Stillwell at that location?
Yes, we were.
Would you tell the jury what happened?
So I was riding, I believe, if I remember correctly, I was riding in the back seat of the vehicle. Viverito, we spotted Stillwell. She was able to say, yes, that's him. I got on the radio, relayed the information about where he was, what he was wearing, what he looked like to the marked units, and then they quickly arrived and were able to take him into custody.
What was it that he was wearing, or what did you describe to the marked units?
Again, that was 10 years ago. I need my report for that description.
I will show you what I will mark as State's Exhibit. (51R) for refreshing your recollection. The report for defense counsel purposes labeled incident number 132352342. You're welcome. And I'll ask you to just take a look at it and let me know if your memory is refreshed without reading the report.
Yeah, so like I said, basically, as I said, I gave the description. I don't remember exactly the clothes he was wearing. I don't think I have it detailed in here exactly what he was wearing. It would have been given over the radio.
Now, what happened after you all gave that? And I'll ask you actually to take a look under, and if you don't recall the time, on that page 4, the third paragraph down, read it to yourself and tell me if that refreshes your memory.
Yes.
So what was it that you told the tactical units to look out for?
There was, I remember telling there was something in his right hand. The rest of it is kind of, I don't really remember a whole lot of it.
What clothing was he wearing?
A red shirt.
Okay. And what happened after you all gave the tactical units the description of the person?
Sergeant Jimenez, Sergeant Heckenkamp were the first ones there. They were able to walk right in the store. Obviously, being in an undercover capacity, I was not going to go in and approach. So they went in and were able to take him into custody fairly quickly, to my recollection.
Now, were you involved with the taking into custody of Shannon Steele?
Not at all.
Okay. And so would that be something for someone else to talk about?
Absolutely, Sergeant Jimenez.
All right. Beyond having told the tactical units what it is that you were looking for, or who it is that you were looking for, did you have any further involvement in that incident itself?
Just the processing of the evidence afterwards. I did all the documentation.
All right. I'm going to show you what has been marked as State's Exhibit 52, which is the evidence document previously provided to the defense in the discovery, and ask you if you recognize State's Exhibit 52. We'll mark that State's Exhibit 52.
What is this thing? Is he refreshing his recollection?
No, we are actually tendering that. It is the, and if you'd like to see it again, I can bring it to you. May I hold that back?
Yeah.
I'm going to give this to the defense to look at before you take a look at it.
You know.
Yes.
Okay.
Your Honor, I'm going to object to 52.
52B?
Your Honor,
52 Bravo?
52 Bravo.
David, Your Honor.
Which one are you going to give him?
52 David.
Delta?
Delta, thank you.
All right, so we're not identifying 52 Bravo at this point in time. It's Delta.
Correct.
Okay, all right. What's your objection to 52 Delta, sir?
It's testimonial that we can go back to the jury, and if I haven't heard any statement that the witness's memory needs to be refreshed.
Can I see it, please?
Yes.
Ms. Love, is some more foundation going to be laid in terms of the items that purportedly on this document?
I can do that? Sure.
All right, why don't you do that first, and then I'll rule on the objection. Christine? Chris? There we go. Dual purpose.
Sergeant P, do you remember what all was collected during that time?
No, I don't.
And at the time that the items were collected, was there a documentation of the evidence that was collected?
There would have been, absolutely.
Now, would that documentation have been reflective of everything that was collected?
It should be an itemized list of everything that was turned into property, yes.
And is that itemized list stored on any kind of database at the Atlanta Police Department?
Yes, our reporting system.
And is that reporting system capable of generating a reproduction or a copy of that itemized list upon coming in?
Yes.
And would that reporting system generate a reproduction of that list based on incident numbers?
It would.
And would the information contained within that reporting system have been put in by you at the time or near the time that this incident occurred?
Yes.
Your Honor, the state tenders 52D as past recollection reported.
Your Honor, it's still a confirmation clause issue, it's still testimonial.
I'm gonna overrule that objection, but I don't think you laid all the foundation for it to be a past recollection report.
Sure, Your Honor, I would have to show him the
Yeah.
document. That was what I was trying to do.
Okay, all right.
I'm going to show you 52D Delta. And would you just take a look at 52 Delta? And I'm going to ask you a few questions about it.
Okay.
Is 52 Delta reflective of items that were collected in relation to the particular report that you've been speaking to the jury about?
Yes, it is.
And was 52 Delta generated on a date different than the time it was, in other words, was that report itself printed out this past year?
The report was printed out, it appears to be last year, yes.
And was that report generated from the reporting system you described to the jury earlier that contains? Your Honor,
I'm gonna overrule the objection, Mr. Short.
was that report generated from the same reporting system you described to the jury earlier?
You're speaking of this particular piece of paper.
No. Not the print.
Right, yes, so all the data that's on this form
Yes.
was input on our reporting system on the date of the incident, yes.
Okay. And were you the person responsible for inputting that data?
Yes,
Your Honor, at this point, the state tendered, and does that report accurately reflect the data that you would have input at the time?
yes.
Okay. So, Your Honor, the state tenders 52 Delta.
All right, any further objections, sir?
Still testimonial, and are we saying to go back to the jury or?
Your Honor, I don't think that this is the time that we discuss whether.
I'm not talking about that at this point in time. That's not an issue for me at this point. Would you have any further objection that you want to make as to 51 Delta? I'll decide that issue later. No? Okay, 51 Delta is admitted.
Thank you, Your Honor. And for the record, it's pursuant to 24-88035.
52.
Sergeant Heath, would you please tell the jury what items of evidence were collected, or rather read the report that is before you?
Sure, so the property that was recovered from Mr. Stillwell was a white Samsung Galaxy S3 phone with battery. That was turned in as evidence. A $1 bill that was turned in as property. A red paisley bandana that was turned in as property. A key ring with 2 house keys that was turned in as property. 1 pair of white Samsung headphones that were turned in as property. 50 individually packaged red plastic baggies containing marijuana that was turned in as evidence. 1 clear plastic baggie containing marijuana was turned in as evidence. And a consent to search form for the location at 322 Glen was turned in as evidence as well.
Thank you. That's all that I have for now. Just one second. Thank you.
Cross, Mr. Sharp.
Could you give me the rank one more time? Your rank?
Sergeant.
Sergeant Heat, good afternoon. My name is Max Sharp. I represent Shannon Still.
How are you?
I am great. First of all, I wanted to talk to you a little bit about the Green Store. Does the Green Store have, in 2013, again, we're talking 10 years ago now, did the Green Store have surveillance cameras, to your knowledge?
I do not know.
Okay. Do you know if it ever had surveillance cameras in any of the time that you worked that area?
I could not tell you for certainty.
Okay. In the 20 to 30 times you arrived there, you never asked for surveillance?
I don't remember what my interactions were 10 years ago, as much as I would wish I could.
Okay, was this a particularly noteworthy event?
In the big scheme of things at the time, no, not particularly.
Is it fair to say that you have a very limited recollection of this incident from August 23rd of 2013?
It's been 10 years, yeah, that's fair to say.
Have you met with the state about this event to prepare your testimony?
Briefly.
Now, you're the officer, or one of the officers who wrote a report in this case, correct?
Correct.
And did you review your report in preparation of your testimony?
I did.
You indicated that you were in the car with Officer Llewellyn and Probation Officer Viverito on that day looking for Mr. Stiller.
Correct.
Okay. You were also looking for other individuals as well, correct?
There was other people that were going to be targeted that day, but he was the one we were looking for at that particular time.
Okay. Now, who recognized Mr. Stillwell?
Viverito.
Okay. You did not recognize Mr. Stillwell?
No.
Okay. Did you know who Mr. Stillwell was?
Not particularly.
So, as someone that was working in the Apex unit,
After last month's massive solar flare added a 25th hour to the day, businesses are wondering, what should we do with it?
Bacon and eggs, 25/7.
You're darn right.
Solar stocks are up 20% with the additional hour in the day.
I'm ruined.
With the extra hour, I'm thinking company-wide power nap. Let's put it to a vote.
This is going to wreak havoc on overtime approvals.
Anything can change the world of work. From HR to payroll, ADP designs forward-thinking solutions to take on the next anything.
correct?
For a specific individual, yes.
Now, as part of your report, I want to be very clear. Now, do you have a copy of your report in front of you?
I gave it to you.
You gave it to me. I gave it to the state.
Yeah.
Thank you.
You're welcome.
May I approach?
You may, sir.
Thank you. I want to be very clear. I am not asking for a specific address.
Okay.
I don't want you to give me a specific address.
Okay.
As part of your report, did you note what was listed as the home address of Mr. Stillwell?
As part of my report. Let me go through the rest of it.
I would draw your attention to the first page.
Yeah, that's where I'm looking. Yes.
Okay, and I'm not asking for a specific address. What general neighborhood was his home address listed as?
It'd be hard to tell you without giving the actual location because it's pretty
Would it be-
obvious.
Would it be in the Thomasville Heights area?
That would be what would be on his ID, yes.
Okay. And that is not in the Canonsville, correct?
Correct.
And it is not in the Cleveland Avenue area?
Correct.
Okay, it's by the federal penitentiary?
Correct.
Now, I understand that you were not involved in arresting my client or searching my client, but you ultimately were given all of the items taken from my client's person, is that correct?
I was responsible for documenting everything that we had. I cannot remember if I'm the one that physically took it to property and turned it in, or if somebody else did that. But I would like to think that I documented everything. So everything is under my name. I would have had to been the one that put it in, so.
And you also wrote the ticket and took out the warrants in this case, correct?
Well, I would have to see the ticket, but yes, I definitely did the warrants.
May I have one moment now?
Yes, sir.
Your Honor, may I approach with 3 documents, and I'm not sure how we're going to do the...
You need to identify them for purposes of record, unless they're one of the exhibits that the state has already shown the witness.
I understand. I'm just not sure of the nomenclature we're going to use with multiple. If you want it to be DS1, DS2, DS3, would that...
Yeah, DS would be fine. DS 1, 2, and 3.
DS1, 2, and 3.
All right.
And they will be
You'll
marked.
need to mark them as that right now, so we can tell or we can track the document. So.
Your Honor, may I approach the witness with DS1, DS2, and DS3?
Shown the State's Counsel already?
Yes.
All right, yes, you may, sir.
Thank you. And Sergeant E, I am going to ask you to look at DS1, 2, and 3. Do you identify those documents?
Yes.
Okay, and what is DS1?
DS1 is an affidavit for arrest.
Okay.
Is it what? I'm sorry.
An affidavit for arrest
Thank you, sir.
filed with the Magistrate Court of Fulton County.
And is that essentially an application for an arrest?
Yes.
And is it for an arrest warrant for charges against Janet Stillwell from August 23rd, 2013?
Yes.
Okay, and who applied for those arrest warrants?
I did.
Okay, what about DS2?
Same.
Okay, and that's another application for arrest warrant on Shannon Stillwell from that same date?
Correct.
And you were the applicant?
Yes.
Okay, and what about DS3?
This is a copy of an arrest citation.
Okay, and this citation is essentially what you give to the individual being arrested, even if they are being arrested on warrant, you give the citation as well?
The citation is what we book them into the jail with, or unless it's like a traffic ticket or a copy of charges, we would give them a copy of it. But yes.
Okay, even though there were, I just handed you 3 documents, there were 2 total charges brought against Mr. Stillwell that day, correct?
In addition to the probation warrant, yes.
Yes. Fair. Now, you are the individual, would you agree after reviewing those documents that you were the individual that sought the arrest warrants on Mr. Stillwell?
Yes.
Okay. Were you the individual that made the charging decisions on Mr. Stillwell, decided what was appropriate to charge him with for these crimes?
Yes.
Okay. And for these crimes, what did you charge Mr. Stillwell with?
Possession of marijuana with intent to distribute, and possession of marijuana, which would be more than an ounce, so felony.
Okay. And the possession of marijuana for more than an ounce was for the bag of loose marijuana found in his left pocket, right? If you're not sure where it was found, I can rephrase.
Where it was found is not what I'm concerned with. I just want to make sure that I have, it's not the total amount of marijuana, and I just charge them separately for, yes.
Okay, and the possession with intent to distribute marijuana was for the 50 individual baggies of marijuana found on his person, correct?
Correct.
And Your Honor,
Your Honor, because I'm going to do this, I was intending to do this after this witness and Mr. Sharp needs it. The state tenders a self-authenticating document labeled State's Exhibit 53 Delta. It is the certified copy of the defendant Shannon Stillwell's conviction for possession of marijuana with the intent to distribute.
All right, any objection, Mr. Stark?
no objection, Your Honor.
Your Honor, under State versus Jefferson, I would like a limiting instruction. I emailed down what wrote. If that doesn't apply to Mr. Williams.
Yeah.
Likewise, Your Honor, for Mr. Newman.
All right.
Your Honor,
Has anyone sent me a proposed instruction?
I did, Your Honor.
Huh?
I did, Your Honor.
Your Honor, I don't have that from Mr. Steele, and I would object to any limiting instruction until I've had an opportunity to at least.
It was sent to you, Ms. Love, at 10:05 a.m.
I've not had an opportunity to review that, Your Honor. And I would ask that the court, it is a certified document. I would ask that the court admit the document, and the court will, of course, instruct the jury at the conclusion of the state's
Hold on,
case.
Ms. Law. gentlemen, I tell you what, we're going to take maybe about, we're going to be in recess till about 3:30. Take a small stretch break, and we'll come back and we'll go ahead and continue examination at this point in time of Sergeant. Sergeant Heap. So you can step off, sir. Just don't discuss your testimony with anybody except the attorneys in this case, okay? We'll call you back in just a minute. All right. Ladies and gentlemen, we're going to be in recess until 3:30, okay? All rise. Okay, our jury's left us. Please be seated. Okay, Ms. Love, I'm in concurrence that the 53 Delta would be admissible. So, and I don't think Mr. Sharp is complaining or saying that it is not. I'm not saying that 53 Delta is not admissible, so I'm inclined to admit it. However, having said that, it's only admissible as to Mr. Stillwell. So a limiting instruction would be proper to say that it's only admissible as to the consideration for him. So I'd need to have an appropriate limiting instruction to give them.
I just had not had, had the opportunity to review the 10:06 a.m. email with State versus Jefferson, so I'm now reviewing it. That's the only reason that I had to object. I didn't.
I understand that, but I mean, I could probably give it at the end. I will give it at the end but I believe that a limiting instruction, at least as to this at this point in time, would be proper. So why don't you all work on that in the next 5 minutes? It doesn't need to be anything substantial. Just probably a couple sentences, and I'll give that to them before this particular they consider this particular conviction.
Your Honor, actually, I do have an objection as to a limiting instruction. This is why. Act 3 of Count 1 is alleged to be an overt act in furtherance of the conspiracy with which Jeffery Williams is charged.
Act 3, what? Count 1?
Act 3 of Count 1. That defendant Shannon Stillwell, an associate of YSL, did commit the felony offense of possession of marijuana with the intent to distribute in violation of Georgia law pursuant to OCGA 161330J1, which is an act of racketeering activity under 161435A, and an overt act in furtherance of the conspiracy. So there is no limiting instruction as to the conviction for Shannon Stillwell and Mr. Williams and the other defendants sitting at the table today.
Mr. Steele, anything further?
Yeah, that's respectfully inaccurate. That is, it's testimonial evidence. Jefferson is driving one that's a COVID-19 case as well. It's a gang case conspiracy. And the fact that some co-conspirator, alleged co-conspirator in that indictment was found guilty or pled guilty is testimonial evidence and cannot be used against the other people who objected to it. What the state is saying is throw away the constitutional right to confrontation, the statutory right. If this was a brute, and I'm just making an analogy, Your Honor, if this was a statement by Mr. Stillwell to the officer and he implicated somebody else here, that would have to go under brute. There's no magic to a RICO case that's a conspiracy. The state has to first prove the conspiracy, and this allegation is testimonial evidence and cannot be used against Mr. Williams, if Mr. Stillwell testifies.
Mr. Steele, we're going to have to just fundamentally disagree on how you read State versus Jefferson. I've taken a look at Jefferson. That is not what Jefferson says. I respectfully to you, but I don't think that Justice Melton, who wrote the opinion at that point in time, in any way saying anything you're saying about that issue in regards to that, because this case covers a business record. They're not trying to get it in under a business record. They're saying that this particular account goes to acts in furtherance of the conspiracy, specifically the one that occurred on or about the 23rd of August of 2013. And I'm looking at it right now.
Please just read the case.
Yeah, I've read it.
That is not what it's saying.
No, I'm looking at it. Whenever the court permits, I'd like to respond. And Your Honor, I can do that.
All right, Ms. Love, go ahead. I'm taking a look at State versus Jefferson, which talks about 16:15:9.
Yes, Your Honor, I have that.
Okay. And you're traveling under 16:14:4, Charlie, is that right? And 16:14:4 Bravo, is that right?
Yes, Your Honor.
Okay.
And that and the distinctions are just glaring. It's inapplicable here. This in State versus Jefferson is an attempt by the prosecutor to establish the existence of a gang by putting in baldly a conviction of a person who's not on trial. There's not any other evidence being offered. They just put in the conviction. Distinguishing our circumstances here, most glaringly, as the court has pointed out, we have alleged a conspiracy under 16:14:4C. And Your Honor, one of the overt acts that the state alleges in furtherance of the conspiracy is the offense that we have shown evidence of through Sergeant Heed, and which we intend to put up at least one more witness to prove the event of August the 23rd, 2013. And because Mr. Sharp sought to introduce, he turned to me and showed me that he was about to attempt to introduce the indictment that was handed down for Mr. Stillwell. And I told Mr. Sharp that I would object to an indictment, a bare indictment being admitted for tender because that has no evidentiary value. I offered to Mr. Sharp to, at this point, during his own cross-examination, to tender the state certified copy that the state intended to introduce in any event as evidence of the occurrence of Act 3, which is alleged as an overt act in furtherance of the conspiracy. Under Mr. Steele's reasoning, it's an attempt to separate something that is solidly together by virtue of count 1 and the acts listed in Acts 1 through 191. He cannot pick apart the overt acts alleged in furtherance of the conspiracy by claiming that the proof of those acts can only be considered by the jury against the person alleged to have considered the acts. So we wholly object to it. It's not applicable. It's distinguishable. And we would ask that the court deny or overrule Mr. Steele's objection.
All right, Mr. Steele, anything else for
Sure. Your Honor, I just emailed everyone again, just a more recent case for State versus Thomas. It's 364 Georgia Field 148, 2022, where the second highest court in Division 2 wrote following. These people were on trial together by the way you're on. Says, Division 2, I'm sorry, it says, phone keeps moving around.
No, I'm looking at it right now, so I see it. The claim that trial court hereby concluding that Jefferson. So, all right. In this case, they concluded the trial court erred in ruling that the prior convictions are wholly inadmissible.
Exactly.
Like other evidence, you got to read on a little further. Admission of evidence of gang activity is committed to the sound discretion of the trial court, and the court's decision to admit or exclude such evidence will not be disturbed on appeal absent abuse of discretion. And again, this is in regards to 1659. And, you know, the state in this particular count is alleging the conspiracy counts 1614 for Charlie and 1614 for Bravo of count 1. So anything else, sir?
Yes, this is the rules of engagement, like you use the term. This is a competition clause issue. It's testimonial evidence it cannot be used against anyone but Mr. Silva, and that's why the limiting instruction is being requested. And that's what State versus Thomas said. That's what Jefferson versus State said.
But you have a conspiracy. That's the problem. A conspiracy means more than one person. So it may not be admissible, just like evidence, as you know, Mr. Steele, having done this a while. Evidence may be admissible for one reason and inadmissible for others. But in a conspiracy allegation, this is what the state's trying to admit. In terms of that, they're using that for that particular purpose.
Conspiracy doesn't do away with statutes or constitutional rights.
I understand that, sir. I do.
The state will not be able to, the court will not find one case that says under 1664 A, B, or C, somehow this is admissible. It's respectfully, Your Honor.
But you're doing it under 1615.9, 1615.3. So that's a little different than what I'm being asked to resolve in this particular issue.
No, that's the state tried to get it in under a conspiracy statute of 6. Those are the gang statutes. And it says that the conviction of one gang member shall be admissible against another. And the Supreme Court of Georgia, Jeffery, said that would make the statute unconstitutional because...
Have they declared that statute unconstitutional?
It would make the statute, the gang statute, unconstitutional.
Have they declared that unconstitutional, Mr. Steele? Yes or no?
Well, it said no. It said because it cannot be used against anyone but that person who pled guilty. That's how it's not, otherwise it would be. That's what Justice Melton wrote on the opinion that you first read on Jefferson. So my point is, we're putting in clearly testimonial. It happens in court. It happens for prosecution. He pleads guilty. I can't cross-examine him. Maybe he pled guilty because he said, I got out of jail that day. I don't have a lawyer. They promised that they wouldn't charge my crime. You know, I don't have any way to cross-examine him. And what the state is wrongly leading this, we're trying to lead this on the court down the path of saying, well, everything comes in against everybody. That's for a jury to determine if they find a conspiracy, and then it's not against everyone. If Mr. Williams, let's say, is in a conspiracy, then the court's going to charge the overt act of Mr. Stillwell, for instance, in this case. If that's done and furthers a conspiracy, it doesn't have to be the act of Mr. Williams. If Mr. Williams is part of that conspiracy, then the RICO is proven. It's the actual transgression into the complication clause that keeps that out against Mr. Williams. It doesn't change anything about the RICO count. The state still has 191 acts, 190 acts, I believe, to then say somebody committed one of these acts if they're involved in a conspiracy, and if that overt act furthered that conspiracy, then that person may be found guilty of the RICO. But that's not to say that every single thing done here means that the confrontation clause is not violated. So that's why I'd like the jury to remain instructed.
Your Honor, respectfully, I disagree. I've consulted with E.D. Carlson, who also disagrees and is in agreement with our position that Jefferson applies to the Gang Act and not RICO. And the overt act is to prove the nature of the enterprise. And in Jefferson, there were no witnesses. He is stating and articulating the exact distinctions that I have made to the court.
All right, Mr. Steele, I'm going to overrule the objection and authorize that when the jury comes back that those particular states 53 Delta will be admissible, and then I will note that there is a continuing objection. All right.
Can I mention something else while you're here for a second? That came up on that last exhibit, 52 Delta, I think it is. In the court, Mr. Sharp made an objection going out with the jury.
I'm not resolving those issues right now. We'll take up those at the end of the trial because some will go out with the jury and some will not be. I'm not going to rule on those right now. I don't need to.
I'll email you. It's just part of the statute because
I don't need to right now, Mr. Steele. Believe me, when we get to that point in the trial, I'll go ahead and take up all of the exhibits that will go to the jury and those that will not, and I'll make sure that we cull those out and we have a good list. I just don't want to deal with it right now. Okay. All right, we're in recess. See you all back in about 5 minutes. You've eaten up all your time, so see you then.
Ask your doctor about Nubeca.
All right, now Sergeant Heeb is back. Okay, all right, so go ahead, sir.
All right, Sergeant Heath.
Hey.
So just to pick up where we left off, you made the charging decisions in this case.
Correct.
Okay, and you charged my client, Shannon Stillwell, with possession with marijuana charges.
Yes.
You did not charge Shannon Stillwell with any gang charges.
No.
I'm going to approach with what's been admitted as 53D, State Exhibit 53D, certified conviction of Shannon Stillwell, 13 SC 12122 up. And hand that to you, sir. Did the state indict Mr. Stillwell on this charge from August 23rd, 2013?
Doesn't appear that they did.
They accused him.
It looks like there was a non-negotiated plea.
Okay, let me.
I don't typically deal with the certified convictions.
I understand. Indictment. And if you go 2 more pages, you can see the specifics of the date.
Okay.
Did the state indict Mr. Stillwell for the crimes of August 23rd, 2013?
Objection as to form, the documents speak for itself, and I don't mind.
I can ask about that.
I sustain the question as to form. You can rephrase it.
Was Mr. Stillwell indicted for these charges from August 23rd, 2013?
Counsel, I'm going to be real honest with you. I have no idea what I'm looking at right now.
I object to the form of the question and
I sustain the question.
Okay. Does the document that you're holding indicate that Mr. Stillwell was ever charged with any gang charges?
No. No.
Did Mr. Stillwell plead guilty to the marijuana charges?
Yes.
I'm going to show you, sir, what's a demonstrative marked State's Exhibit 1B. Hold this up for you. Do you recognize what this is?
It's a map.
Okay, does it have some green and red writing on it?
It does.
All right. Now, is this a map of a certain section of Atlanta?
It appears to be.
Okay, is 322 Glen Street on this map?
You're going to have to bring it closer.
Certainly.
No.
Could you say it louder?
No.
Okay. 322 Glen Street is north of this map, correct?
Yes.
Okay. Thank you. Nothing else.
Any further examination?
no, Your Honor, not at this time.
Okay. At this point in time, may we excuse Sergeant Heeb permanently or temporarily as a witness?
Yes, Your Honor.
Permanent?
Yes.
Okay. Sergeant Heeb, appreciate your patience with us. We're going to go ahead and permanently excuse you as a witness. Just don't discuss the testimony of anybody except the attorneys in this case, okay?
Yes, sir.
All right, thank you, sir.
Sir, the documents?
Just leave those with Miss Weaver, my court reporter, right here. All right, call your next witness, madam.
Your Honor, still on Act 3, we call Sergeant Jimenez.
All right. Summon Sergeant Jimenez, please. All right, Sergeant Jimenez, good afternoon, sir. If you would please approach the witness stand. Once you get there, if you turn and face Sergeant Ingram, be sworn as a witness, please, before you sit down.
Raise your right hand. You swear affirm testimony given today the truth, the whole truth, and nothing but the truth.
I swear.
Have a seat. State and spell your first and last name for the course, please.
First name Scott, S-C-O-T-T. Last name Jimenez, J-I-M-E-N-E-Z.
Good afternoon, Sergeant Jimenez.
Good afternoon.
And if my southern accent makes it wrong, as I say your name, you feel free to correct me.
No problem.
Would you tell the jury where it is that you currently work?
I currently work in APD, Zone 5, the traffic unit,
How long have you worked there?
since June 29th
Of this year.
of this year.
Prior to that time, where did you work?
Prior to that, with APD for the last almost 18 years, in the open records unit.
Are you post-certified as a law enforcement officer by the Peace Officer Standards and Training Council of Georgia?
Yes, I am.
And have you remained post-certified during your entire time with the Atlanta Police Department?
Yes, I have.
Prior to working with the Atlanta Police Department, what was your background?
Prior to working with the Atlanta Police Department, I worked at a large law firm in town. I handled litigation discovery for that law firm.
In August of 2013, you reported with the Atlanta Police Department.
Yes, I was.
And on August the 23rd of 2013, did you have occasion to be involved in a detail that consisted of apprehending a person wanted for a probation violation?
Yes, that's correct.
And was that person Shannon Stillwell?
That is correct.
Would you tell the jury what your role in that detail was?
Sure. On that day, I was a sergeant in the Apex unit, one of two supervisors working that day. The detail, or the operation for the day, the assignment for the day, where there were two people that were wanted for probation violations, and we had an attached probation officer from the Department of Corrections working with us that was familiar with the actual arrest warrant and and the wanted subjects. That person was in a car of undercover officers in an unmarked vehicle. They went to the area where the wanted persons were known to hang out, and they spotted the wanted persons in the area. I believe it was Officer Heeb called out on the radio after the person later identified as Shannon Stillwell was identified walking up Windsor Street. He gave out the description of the person, what they're wearing, height, weight, and identified that person as one of the wanted people. I was in a car with a marked vehicle in uniform with the other sergeant. Sergeant Heckenkamp was driving. I was in the passenger seat. We were coming down Glen Street. And the wanted person that was identified as Shannon Stillwell was over the radio. He was supposed to be coming from behind the store at the corner of Windsor and Glen. Typically is referred to as the green store. Mostly because of the paint color that it usually sports. There was a parking lot in the drive that goes behind that store and comes out from the Windsor side behind the store and onto the Glen, kind of a concrete driveway area on the Glen Street side. Sergeant Heckenkamp and I were driving eastbound, I believe eastbound, yes, eastbound on Glen, and I spotted the subject that was, the description was given over the radio, and I told Sergeant Heckenkamp to stop the car. I exited the vehicle, approached the identified subject, and he had a cell phone in his hand, and then he looked back over his shoulder where he had come from, and then placed the cell phone into his pocket. I noticed that as a pre-flight indicator that he may run. So I hastened my pace, went ahead and grabbed his left wrist. And executed the arrest. We guided him to the ground. Sergeant Heckenkamp cuffed him up. I asked him if he had anything on him at the time and that I should know about, and he said that he had some marijuana on him. After we got him cuffed up, stood up, I retrieved marijuana from his left pocket and the cell phone from his right pocket.
The marijuana that you retrieved from his left pocket, did it come in any particular form? Was it in any particular?
Yes. The marijuana was packaged in two bundles. One was a kind of a sandwich bag of loose raw marijuana. I believe it was roughly probably an ounce from the volume. And then the other package was another bag that had, I believe, roughly 50 smaller Ziploc bags. They were transparent red Ziploc bags, each containing roughly probably a gram of marijuana apiece. So those two packages were both in his left pocket.
Was there any significance in terms of your experience as a law enforcement officer to the packaging of 50 smaller baggies of marijuana?
Yes, in my experience, that volume of individual bags of marijuana would indicate intent to distribute, sale of marijuana.
And did you inquire, did you ask Shannon Stillwell whether he had anything on his person prior to learning that he had the marijuana on his person?
Actually, just in general, once we, restrained him, placed him in physical custody, asked him if he had anything on him that I should know about. Just a general question, and his response was that he had some marijuana.
Okay. Thank you. Just 1 second, please. Actually, the Mechanicsville area, is that in Zone 3?
Yes, it is.
Just 1 second. Would you explain to the jury just as succinctly as you can the borders of the Mechanicsville community of Atlanta?
A little more difficult. I haven't operated in specifically in the Zone 3 area, so I would probably say, I think coming down McDaniel, going all the way over. It's difficult for me to say, and the borders have changed probably 2 or 3 times since we've changed zone borders, so I really can't answer it specifically.
Oh, McDaniel is in the Mechanicsville area?
It is, yes.
Oh, thank you.
Sure.
That's all I got.
Cross, Mr. Sharp.
Hello. Is
Hi.
Sergeant Jimenez?
Currently Lieutenant Jimenez.
Oh, I'm sorry. Lieutenant.
Oh, it's okay. No worries.
All right. My name is Max Shard. I represent Shannon Stillwell. Just a couple questions. You are the individual that first put hands on my client?
That is correct.
Okay. And you didn't, he told you, he was open and honest with you about the marijuana he had on this person, correct?
That is correct.
Okay. And this marijuana that you found, you determined that he was, it was packaged for sale, correct?
The packaging would tend to indicate that it was packaged for distribution.
Okay, and distribution means for sale.
Yes.
And he was charged as such, correct?
That is correct.
Do you have any evidence as to where he got this marijuana from?
No.
Do you have any evidence of what he was planning to do with this money that he was going to make from these marijuana sales?
No, I don't have any information on that.
I have nothing further. Thank you.
Any redirect?
Just briefly. Lieutenant, I'm sorry, I apologize, Sergeant.
No
I'm
worries.
showing you what has been marked as states with 47 Delta, a package that has been shown to the defense previously, and I'm showing to you now. Would you take a look at 47 Delta and open it up and look inside? recognize what is 47 Delta?
I reckon as a cell phone. It's been 10 years since this case, so I would have to rely on the labeling from the property recovery.
Okay. And when you say you would have to rely on the labeling of the property recovered, I'm going to show you State's Exhibit 52 Delta and ask you in conjunction with State's 47 Delta, are you able to identify that as a cell phone you recovered from Mr. Stillwell?
Yes, from the case number, being the case number from this arrest, and also the 4-digit ID number on here is Officer Heeb. That is his 4-digit ID number on here. He's a case agent for this, and also the undercover officer that had called out the positive identification of Mr. Stillwell on the scene.
Your Honor, State Attendance 47 Delta.
Any objection to 47 Delta, sir? That it?
Yes.
All right, overruled. It's admitted.
Thank you, that's all that I have.
Your Honor, I just had one.
One what?
Refile. And you gave some weights for the marijuana. Was the marijuana, to your knowledge, weighed, or were those just approximations that you were?
The approximations are from my, kind of a visual description of those, but I believe when they were processed, they were all the items were weighed.
Okay, but you don't know the official weights from weighing of the items.
I do from reflection of my recollection on the report. Yes.
Okay. What were the weights?
I believe the weights were 50 grams, I believe, for the packaged 50 bags of marijuana, and I think it was 28 grams for the loose raw marijuana in the sandwich bag, I believe. But I would have to refresh from the report.
Just so we're clear, 50 grams is for the total of all the bags.
No, I believe it's 88 is the total for both.
I'm sorry. 50 grams is the total for all
Your
of
Honor,
these
I would
small.
ask the object and ask
Basis.
that the witness be allowed to complete his answer.
Yeah, let him finish his answer first.
With the numbers, I would have to actually look at the report because the report has the actual, accurate numbers. I only know, what I pulled from his pocket, and my estimation at the time, I didn't turn the drugs into the evidence room, so that's where they would be weighed, and they were documented in the report.
Fair enough. But when you said 50, you were talking about the entire total of all the small bags, not each bag.
I believe so, yeah.
Okay. All right, nothing further. Thanks.
All right, anything further? If not,
Your Honor, what was the 88 that you mentioned?
I think there was a total. I think the total grams of marijuana, but I'd have to look at the report for that.
Okay, thank you. That's all I have.
all right. All right, may Lieutenant Jimenez be permanently or temporarily excused the witness? All right. Lieutenant Jimenez, appreciate your patience with us. I'm going to go ahead and permanently excuse you as a witness, but don't discuss your testimony with anybody except the attorneys in this case, okay? All right.
Thank you, Your Honor.
Thank you, sir. All right, call your next witness, madam.
Your Honor, as to Act 4, the state calls Andrew Phillips.
All right, summon Andrew Phillips, please.
And Your Honor, with respect to this witness, if we could invoke the same provisions as to.
Okay, I'll ask the members of the meeting respectfully if you would just not film our witness. You can take other audio or other testimonial evidence. I appreciate that. All right. Do we have Mr. Phillips available?
Yes, we do.
Okay, all right, let's bring him in.
Thank you.
All right, Mr. Phillips, good afternoon, sir. Sir, if you would please approach the witness stand once you get there. Before you sit down, if you would turn and face Sergeant Ingram, be sworn as a witness.
Raise your right hand. You swear affirm testimony you give today the truth, the whole truth, nothing but the truth.
I do.
Have a seat. State and spell your first and last name for the course and I'm going to do please.
State and spell. Andrew Phillips, Andrew, Phillips, Phillips.
Good afternoon, Mr. Phillips. How are you?
Very well, thank you.
Good. Mr. Phillips, would you tell the jury just a little bit about yourself? Are you from Atlanta?
Yes, ma'am.
All right. And generally, in 2013, what area of Atlanta did you live in?
Buckhead.
On June the 10th of 2013, were you living in Buckhead then?
Yes, ma'am.
And on July the 10th, sorry for you for asking previously about June, July the 10th.
Yes, ma'am.
On that date, are you married?
Yes, ma'am.
Did anything of significance happen on that date that caused you to reach out to the Atlanta Police Department?
Yes, ma'am.
Would you tell the jury what it was that happened?
I'd returned from being on vacation and noticed that a door was open or ajar. And I called 911, the police department showed up, they cleared the house, then I went in and began to notice that some items were missing.
Now, the address that you lived at then, is that the address that you still reside at?
No, ma'am.
What address did you live at on July the 10th of 2013?
11 Demarest Avenue, Atlanta, Georgia, 303. I can't remember the full zip, sorry.
That's okay. Was that a house, a townhouse, an apartment, or something else?
It was a house.
Standalone home?
Yes, ma'am.
All right. And could you describe when you say your front door was open? Had it been kicked in, or was it just ajar?
It was ajar. There was no signs of any forced entry.
Had you left your door unlocked?
I can't say that for sure or not.
All right. What all did you find was missing inside your home?
Specifically, 2 firearms. One was a handgun, one was a shotgun. I believe a laptop and a blanket, to be exact.
A blanket?
Blanket.
What kind of blanket?
Like a blanket that had been over the back of a armchair.
Could you tell the jury what kind of handgun it was that was missing?
It was a Sig Sauer.
P226?
That's correct.
All right. And what kind of laptop was missing?
An Apple.
Who did that belong to?
My wife.
Now, was there any way that you were able to, was there anything else that was present or absent at the time that you arrived home? In other words, was your alarm system, did you have an alarm system?
We did have an alarm, but I can't say whether or not it had been on or not.
And when you got home, was there any mail or anything at your doorstep to leave any indication as to?
Actually, there was mail on the front doorstep now that you say that.
Okay, what was there?
It was I think a small brown package.
Okay. And on what date was that UPS package delivered?
I do not recall.
Showing you a copy of the incident report from that incident. Refresh your memory?
I'm sure it would.
All right. I'm going to show you page 2 for council's purposes of incident 131910027. And just for reference's sake, we will label it State Exhibit 54R. R as in Romeo. Did I get that right, Judge? Okay. Would you take a look at the last line of that paragraph?
Okay.
Without reading it out loud, just let me know if it refreshes your memory as to when the package was delivered.
It does.
Okay. And you arrived home on the 10th, was it, of July?
Was it that sounds accurate.
And what date was the package delivered?
Based on what I just read there on the 9th.
Okay. I'm going to show you, and Your Honor, this time we have an exhibit that has been made safe, but we are also bringing in a weapon into the courtroom, so we need to make the court aware.
That's fine.
I'm going to show you what has been marked as State's Exhibit 12 Bravo.
Yes. All right, madam, you may proceed when ready. Okay.
Now, Mr. Phillips, did you ever receive back your firearm?
No, ma'am.
All right. At some point, did you reach out to the Atlanta Police Department to tell them a serial number or any other identifying information for the firearm?
I believe so, yes, ma'am.
Now, do you recall what that serial number was?
Not off the top of my head, no.
Okay. And do you recall what your firearm looked like?
Yes, ma'am.
Would you recognize your firearm if you saw it again?
Yes, ma'am.
Do you recognize the firearm inside the box that is labeled 4054 Delta?
Can you flip it over?
Go ahead, you flip it.
I'm sorry. Not 54 Delta. Hang on one second. 40.
12 Bravo.
12 Bravo.
Without confirming the serial number, yes, it does look like my firearm.
And are you able to tell the jury what make and model of the firearm it is that you're looking at?
Yes, ma'am.
What is it?
It's a Sig Sauer P226.
And what is it about that firearm that makes you believe that that is your firearm?
It's very specific. The P226 model is the firearm that is issued to the Navy SEALs. So I can see the logo on there and know that.
All right, and when you say that it is a very specific firearm issued to the Navy SEAls, were you a Navy SEAL?
No, ma'am.
Why is it that your firearm would have, or you would have a firearm specific to Navy SEAls?
I just thought it would be cool to own that specific firearm.
All right. With showing you a mark with a serial number listed on it, refresh your memory as to the serial number?
I'm sorry, can I get that question one more time?
Would showing you a warrant with the serial number listed refresh your memory as to the serial number for your firearm?
To answer your question, I don't know if it would. Without seeing the purchase document from when I bought it, I couldn't confirm the serial number.
Okay, but you can confirm, or can you confirm that can you confirm that the serial number that was on your purchase document is something you conveyed to the police?
Yes, ma'am. I did have to call and get that document from the store that I purchased it from.
Okay, and the document that you got from the store, did you read from that document when you gave that number to the police?
Yes, ma'am.
Now, do you recall who it was that you, that responded to your residence when you reported the break-in?
I do not.
Do you recall the, whether there were more than one officer, or whether it was a female or a male or anything of that nature?
I want to say that there was 2 police officers.
Okay.
It was late and it was dark, and I just got done traveling.
Did you ever receive any of the items back, or did you ever receive notification that any of your items had been found?
I did receive notification that this firearm next to me had been found.
And did you attempt to retrieve that firearm?
I reached out to find an understanding of the whereabouts of the firearm.
What do you mean?
Just once they had contacted me, I was curious.
Okay. And were you allowed to get your firearm back?
No, ma'am.
All right. Now, at the time, had you given anyone permission to be in your home during that time?
No, ma'am.
And had you specifically spoken to anyone or a person by the name of Jeffery Williams and given him permission to hold or to have your firearm?
No, ma'am.
Were any of the other items that were stolen from your home ever recovered, as far as you know?
No, ma'am.
Does the name Officer Monheim actually, just one moment, Mr. Phillips. Was there ammunition taken with your handgun?
I would say that yes, there was.
And what about the other firearm that you talked about? What was that firearm once more?
It was a shotgun.
All right. Was that shotgun ever recovered?
Not to my knowledge.
And And do you remember any other identifying information about the shotgun?
I can tell you that it had a brown stock and a brown forward grip.
And was there any ammunition with the shotgun?
No, ma'am.
Thank you, sir. I believe that that's all that I have.
Thank you.
Mr. Sharp? Or, I'm sorry, Mr. Adams.
Yes, sir. Let's go. So, good afternoon, sir.
Good afternoon.
My name is Keith Adams. Represent Jeffery Williams. You and I have never met, correct?
Correct.
So, if I heard correctly, in July of 2013, you were on vacation with your spouse, correct?
Yes, sir.
How long were you gone?
I can't say for sure, but I feel like it was 4 to 5 days.
Okay. I mean more than a day or two, right?
Correct.
Okay. And the date that we've heard referenced before, July the 10th of 2013, that's the day that you came back, correct?
That sounds correct.
You come back, and before you go in your house, you notice that your door is open, it's ajar.
On the way up the driveway, we noticed the door. Yes, sir.
There was a package that had been delivered on that day, or at some point you come to find out it was delivered on that day, right?
I believe, based on what she showed me, it had been delivered on the day before.
Okay. She being that prosecutor?
Yes, sir.
Okay. So there's a package there, but you don't know how long that door has been ajar, right?
Correct.
You don't recall whether or not you had your alarm set, true?
Correct. I believe that the alarm was not on, but I can't confirm that.
Okay. And what we know for a fact, well, what you've told us, is that the door did not appear to be damaged. It wasn't kicked in or anything like that. It was just ajar.
Correct.
This is a standalone house.
Correct.
In a neighborhood.
Correct. Yes, sir.
Subdivision, cul-de-sac, something like that?
Just a neighborhood, normal neighborhood with homes next to one another.
Okay. Bunch of families live in the neighborhood, some with kids, some without?
Correct.
Okay. There been other thefts or burglaries in the neighborhood as far as you're aware?
I feel like some things had taken place, but I can't recall.
Sure. And so what you can tell us is that you come home and 2 guns, a laptop, and a blanket are missing from the house.
That sounds accurate.
Okay. May I approach, Judge?
You may, sir.
All right. The item that you've been shown here that's been previously made safe by, made safe, is a gun. It's a black gun, right?
Yes, sir.
Looks kind of like the gun that you had, right?
Correct.
But you don't know the serial number.
Correct.
Right. And so you can't identify, I mean, there's more than one black gun out there in the world, right?
I can say, yes, sir, but when they called me with that gun specifically, they had matched the serial number to the serial number that I had submitted.
Okay, but for purposes of you telling this jury that you know for a fact that this item that we're looking at right here, I'm gonna move it so that correct, that does have a serial number on it, you don't know that serial number. You can't recognize it by that serial number.
Not off the top of my head, no, sir.
All right. You never retrieved it, or you never got it back. They never gave it back to you, or gave any gun back to you, did it?
This is my first time seeing it since.
Okay. Or seeing what you believe to be
correct.
What might be your gun.
Correct.
Okay. Do I recall or know correctly that the officers who came out dusted the location for fingerprints?
I believe they did. It was a long time ago.
Would that have been APD, the Atlanta Police Department that came out, or was it another jurisdiction?
I want to say that it was APD.
Okay. And so as far as you know, they conducted some degree of investigation involving and including dusting for fingerprints, right?
Correct.
Do you remember whether they told you, or do you remember them telling you that they were actually able to retrieve or to lift?
Objection as to hearsay.
I'll sustain it as to this point.
Okay.
I'll sustain the question.
All right. Well, certainly, as far as you know, the Atlanta Police Department, detectives, officers, whoever came out, would have some information about whatever it is they found.
Objection as to
Right?
speculation.
I'll sustain the question as a speculation.
Okay. They came out and investigated, right?
Yes, sir.
All right. APD, Atlanta police officers.
I believe so.
All right. Okay. Mr. Phillips, thank you. That's all I got.
Thank you, sir.
Anybody else? Anything further, madam?
Your Honor, I don't have anything further now. I would ask that Mr. Phillips temporarily be released and allowed to be recalled.
Okay. Mr. Phillips, thank you for your patience with us. I'm going to go ahead and temporarily excuse you as a witness. So what that means is at some point in time, you may be subject to being recalled. We'll certainly give you enough advance notice in order for you to get here timely. But don't discuss your testimony with anybody except the attorneys in this case, okay?
Understood.
Right.
Thank you, Judge.
Thank you, sir. All right. Ms. Love and a representative, can I get you all to come on up, please? And the rest of you, put your headphones on, please. All right, it's Talk Radio. I'll take it up in just a second, Christine. All right, ladies and gentlemen, how about we take 5 minutes? I have it on good authority that we're going to go ahead and maybe take one more witness and then we'll conclude for the day. But, you know, what do I know, though, right? Okay, so take 5 minutes or thereabouts. We'll call you back in, okay? All right. All rise. Is that correct?
Yes, sir.
All right. Okay. Mr. Steele, what is your motion, sir?
I'd just like to remind the Honorable Court, I made a motion previously and asked the state to ensure that with Officer Mannheim, or if you recall, but he stopped Mr. Williams on September 9th of 2013 in a traffic stop. Mr. Williams did not have the driver's license. He stated that he ran Mr. Williams' name. He stated to me, when I interviewed him today, that the way he was able to see Mr. Williams' pictures, he ran it on prior arrests. So I would like that to be eliminated.
That
prior arrest.
issue of prior arrest?
Yes.
State have any issue about that?
I don't, unless there's a door opened through cross-examination.
Okay, could you instruct him to not reference that,
Yes.
please?
Yes.
Okay, all right.
He also stated in the police report, and you handled this last time as well, that Mr. Williams was currently on probation to the end of the police report. I believe Mr. Williams was not on probation because his brother used his name as a juvenile, and that was the probation. But I'd like that to be excluded. I believe you already did that, but I just don't want to get into a position where I'm asking for a mistrial.
Okay, can we also tell him not to mention anything about that, Ms. Love, as well?
Yes, Your Honor, I believe
Okay.
that. I believe, Your Honor, that given what Officer Mannheim will be testifying about, that there will be no need for him at all to go into anything like
Well, let's just make sure that we cover those two items in particular, okay?
we will do that.
Okay.
Thank you,
All
Judge.
right. Anything else?
Yeah, the final one is you admitted over my objection the statement that Mr. Williams made. There's a gun found in the passenger seat, if you recall, Your Honor, and then Mr. Williams allegedly said that the gun belonged to a friend.
Yes.
He's in custody. Mr. Officer Mannheim then asked Mr. Williams whose gun is it, and Mr. Williams did not answer. There was no Miranda. He was in custody. He was asked the second. I understand you admitted Mr. Williams' statement that it's my friend's gun over my objection, but the next part would be interrogation. You found the first part to be spontaneous.
Yeah.
Okay.
Fine.
So he's basically asking about the second, I guess, or the silence is an admission.
Your Honor, what I'm asking,
And it's post-arrest.
Post-arrest silence. So.
I want to be really clear here because this is part of some of the stuff that I was mentioning earlier regarding the opening. The state vehemently moves the court to admonish counsel for Mr. Williams to in no way attempt to solicit self-serving hearsay from Officer Mannheim unless the state asks for that information, because we would be entitled to as a statement of a party opponent.
You open the door, Mr. Steele, it may come in, so you're just, you're just warned at this point in time, okay?
Mr. Steele's, I'm asking that the court preclude Mr. Steele from asking Officer Mannheim what Mr. Williams said. When he said that is a friend's gun, that is a self-serving statement.
Well, that's admissible. I said that was admissible already.
No, Your Honor, it's admissible if the state asks it because it's the statement of a party opponent, not Mr. Williams. What we're saying is they can't solicit that.
Are you going to ask them that on direct?
No. And Mr. Williams can't because that is self-serving hearsay. Baldly here. If I may continue talking to the court, Mr. Williams can't because it is self-serving hearsay, Your Honor. So we would ask that the court preclude Mr. Williams from asking Officer Mannheim or attempting in any way to solicit in front of the jury the self-serving statement that the firearm belonged to a friend. If the state seeks to get that in, the state can do so because it is a statement of a party opponent, but it is not permissible for Mr. Williams to attempt to get his own words in through a witness that is not Mr. Williams.
Okay. All right, Mr. Steele, what do you say about that?
I moved to exclude that statement, so that's okay. But I'm just talking about the second part, the post-arrest silence.
I'm talking about the first part.
Yeah, we're not going to talk about that, are we, Ms. Love?
I'm talking about the first part.
No,
I don't have any.
Mr. Steele doesn't have any. He's already asked me to exclude that. I'm not going to exclude it. Okay, you're saying that he can't he's telling you he's not going to elicit that or solicit it, okay? But his clarity is the second statement where Mr. Williams, he asked Mr. Williams a question.
Right.
That's what he's saying would be, he's motioning in limine for me to exclude.
Your Honor, I don't have a problem with the exclusion of the, I guess, the silence, and I want to make certain that I'm clearly responding to what has actually occurred and not a version of it that is inaccurate. So if the court will give me one moment, as I do that, I ask the court in limine, I'm moving the court in limine to preclude Mr. Steele from attempting to elicit self-serving hearsay. That is Mr. Williams' statement that the gun found in the car with him that was stolen belonged to a friend. That is what I am moving in limine for the court to do, because it is impermissible for that to be solicited by the party who made the statement. He can get on the stand and say it, or the opposing party can have it admitted if we so desire to do so or sought to do so. But Mr. Williams, Mr. Adams, and Mr. Steele cannot ask a witness what their client said when it is self-serving hearsay, and I have the law for that. I'll give it to the court.
Again, I don't think he's asking about that. Mr. Steele, you're not going to ask any questions to elicit that, right? Correct. Okay. And Ms. Lovin, you're not going to ask, or you're going to instruct Officer Meyerheim not to mention any of the silence or post-arrest silence in response to that particular question.
Right.
Thank you, sir. Of who owned the gun. Okay, so those three things you need to go ahead and advise Officer Mannheim as to. Take 5 minutes or so. We'll come back, okay?
Okay, thank you.
Thank you, Counsel. All right, we're in recess.
Let me just go out there and make it happen. No, I'm going to go back. What? No, can you get Mannheim down here? Or whatever he is?